Get ready. 3 seconds. 2 seconds. Start. This appeal is directed against the judgment and order dated 4/7/1998 passed by Additional Session Judge Jorhat in session case number 57, convicting the accused appellant under section 302 IPC and sentencing to rigorous imprisonment for life and also to pay a fine of rupees 5,000 in default further rigorous imprisonment for 3 months. The facts of the present case reflect how a minor incident may cause a major shock and loss of human life. The accused and the deceased were own brothers living in separate houses within the same campus. On 31/3/1996 at about 4 p.m., while the deceased was dressing a chicken and his son was standing nearby, the dog belonging to the accused suddenly jumped on the young boy, whereupon the deceased asked the accused to take proper care of the dog, keeping him tight. Thereafter, an altercation took place between the two brothers, whereupon the accused picked up a bamboo post and dealt a blow on his own brother. The injured brother was moved to hospital and the FIR was lodged. Though the treatment was given, the injured succumbed to the injury on 9/4/1996. The accused was tried for the offense under section 302 IPC, and during trial, the prosecution examined as many as 10 PWs. On conclusion of the trial, the learned additional session judge convicted and sentenced the accused appellant as stated above. PW1 is the wife of deceased and PW2 is the son of PW1. PW2 is aged 14 to 15 years and a student of class 8 at the relevant time. They have deposed that the incident took place while the deceased was dressing a chicken and the dog belonging to the accused jumped on the body of PW2. Some altercation took place between the two brothers and the accused appellant dealt a stroke on the head of the deceased with a bamboo post. PW3 is the another son of PW1 and PW4 is the brother of the accused and the deceased. The wife of PW4 was present at the time of occurrence. PW4, after arriving at the place of occurrence, took the injured to hospital. PW5 is the sister-in-law. PW6 is the own sister of the accused, and she claimed that on hearing a hue and cry, she came out and saw the deceased lying and being treated by applying water on his head. PWs 6 and 7 have been declared hostile, but their evidence stands well established that an incident had taken place on the date of occurrence between the accused and the deceased. So far, the evidence of PWs 1 and 2 is concerned. They are the two eyewitnesses, and we find absolutely no reason to disbelieve these two eyewitnesses. As the incident had taken place in broad daylight in their house, they are the natural witnesses and they have deposed to that effect. Moreover, they had no animus with the accused and nothing has come out to show that they had falsely implicated the accused and thereby allowing the actual assailant to go scot-free. The witnesses had not exaggerated anything in their statement. The learned counsel for the appellant has submitted that there was no motive or evil intention on the part of the accused in causing the death of his brother, and the assault was made at the spur of the moment in the view of the altercation that took place in between the two brothers. In this respect, we may refer to the medical evidence on record. PW8, who held the autopsy over the dead body, the doctor has categorically stated that there was no external injury on the person of the deceased. The doctor found that there was accumulation of blood into base of brain on either side, and there was hemorrhage in the brain, and in the opinion of the doctor, the death was due to shock and hemorrhage as a result of intracranial injuries. On consideration of the nature of injury and the fact that the accused dealt a single blow on the vital part of the body while an altercation was going on in between the two brothers, we have no hesitation to hold that there was no intention to cause death, and the act of the accused constitutes an offense as defined under Section 300 IPC, and the offense is punishable under Section 304 Part 2 IPC. We have heard the learned counsel for both sides on the point of the sentence. The record shows that the accused was in jail custody from 3/4/1996 to 12/7/1996, and thereafter he is in jail custody since the date of his conviction, that is 4/7/1998, which goes to show that the accused person was in jail custody for more than 6.5 years. Considering all aspects of the matter and the fact and circumstances of the case, we sentence the accused appellant to the period of imprisonment already undergone by him, and he may be set at liberty forthwith if not wanted in connection with any other cases. Stop.